Welcome, everybody, to The Lawyer Show. I'm your lawyer, Jeremy Rosenthal, and The Lawyer Show is our weekly podcast where we do things by lawyers, for lawyers, about lawyers. Today is a day that I have had circled for some time now. It's a very special day here on The Lawyer Show because part of being a lawyer, it's hard to explain some of the things. I mean, we learn a lot in law school, right? We deal with clients a lot. We deal with issues. We deal with judges. We deal with people. But there's a culture that kind of comes with being a lawyer that's really sort of hard to quantify and explain. And my guest today is somebody who I think embodies more than probably anybody else I know, a person who I can just sort of equate to on the same level when it comes to putting up with other lawyers, because that's a big part of it. And that's things that's something that they never teach you in law school. They never teach you that, yeah, you can, you're going to deal with some pretty egocentric people. You're going to deal with a lot of egomaniacs. You're going to deal with a ton of passive aggressive. They don't teach you these things in law school. And in fact, they ought to. And if they were going to teach this in law school, I think I've got on my podcast today, my co-counsel, John Nagy, I think would be a professor, I think, in being able to deal with some of these types of folks. John Nagy, and I'll let him introduce himself here momentarily, but John has, I've known John for 20 plus years. And John and I went to SMU School of Law together. John and I were co-counsel on Potter v. Schrackle, a landmark case that we litigated as third-year law students, right, where we first learned to put people on speakerphone when we wanted to subject them to our kind of make them feel inferior. And John has been around, again, John's been around the block. John has been, he worked at Big Law, where he learned how to navigate not only difficult co-counsel or difficult opposing counsel, difficult partners that you deal with, and getting also to put up with the shenanigans of your coworkers. That can't be put out completely either. John worked in insurance law, and John now is he is the chief of litigation for the Indiana Department of Health. And so I welcome to the Lawyer Show Professor John Nagy.
Thank you. Yeah, we're coming to you live from Indianapolis. And you left out, in addition to, as you were running down our history, of knowing one another, you left out that fun fact that Rabbi Jeremy Rosenthal did indeed preside over my wife and I's wedding, which, is interesting given that we're Catholic, but seems like it's worked out okay.
Made for an interesting day.
Yeah.
It really did.
Sure.
It really did. And that's a very, I did not include that. The county of Sonoma County, right? They have a money-grabbing little thing, which is you can be licensed for one day to marry somebody, right? And so they made me take a class. You know this, right? Because you kind of steered me to this, and I was very honored to conduct that ceremony. And so I had to go take a class at Sonoma County where the most important topic was, are you going to pay your $85 with a credit card or are you going to pay in cash? That was the most important thing of this. They didn't really go much on there, but yes, that is one of my talents. And yeah, you guys just celebrated an anniversary.
We did. Yeah.
Very good.
And as a matter of fact, the license is right there on the wall.
Very good. Now, in your background, you've set this up quite intricately and quite deliberately because there's a lot of messages here. And by the way, one thing that we have not traditionally, one thing that we're going to be improving about the Lawyer Show podcast is our question and answer stuff. So I would like, again, if you are watching, and probably there's, I know, I don't know, maybe, 7. No kidding, really. We need questions
I was going to
today.
guess 7.
Is that right? Lucky 7.
I was going to say, hey, you know, for all 7 people or however many that are watching this and are wondering why you are having an Indiana lawyer as a guest. You know, by way of background, I actually started my legal career in Dallas, practiced with a couple of firms, went to law school at SMU, spent a total of almost 10 years practicing down in Dallas County. You know, so pony up. My wife is an Aggie. Also, I feel like at some point during this little chat we're having, we're going to have to talk about the Texas A&M School of Law and its ascendancy.
Yeah, no, you were the one that pointed that out to me. That may be where they put you on faculty, in fact. So, yeah, let me write this down because I do want to get back to it. But
don't worry, I have it written down. See, I came prepared. Unlike some of those lazy guests you've had, like Bo Calvis, I actually came prepared.
Yeah, true. Again, yeah. Well, Bo's talent is, you know, any lawyer, John, any lawyer can be prepared. Any lawyer can get ready. Any lawyer can do a lot of work. They can do some research. They can stay up late at night getting ready. They can rehearse. Any lawyer can do that to be successful. It takes a special one just to show up and pull it out of his or her, you know.
That's a brave soul.
Well, and that's Bo Calibus. Bo can do that. He's talented enough to do that. And anyway, so I do want to get to, you know, kind of first and foremost, before the ship gets too far away from the dock here, I do want to talk about what are some of your favorite lawyer mind games that you like playing. I don't know if you have the opportunity to keep doing this with opposing counsel.
You had told me that was a thing that you were interested in exploring, and I know back in the day, and by that I mean, you know, maybe 2005, 2006, you know, that was a thing that we burned a fair amount of energy on. I'm going to be honest with you, man. Like, I feel like nowadays the most subversive thing I can do to the lawyer on the other side is kill them with kindness, you know, because half the time they don't know what to make of it. Mm-hmm. And I don't mean that in a, you know, hey, you can call me Chip kind of way, and I'll let you explain that, right? But just killing them with kindness. It's amazing how well it works in just kind of, you know, with the average practitioner you're going to deal with, and just kind of settling them down. And I get, you know, the legal culture, if you're practicing in Dallas-Fort Worth, you know, it's a very different ball game in that, you know, it's a huge bar. I think there are more lawyers in Dallas-Fort Worth than in the entire state bar of Indiana, right? So there's a ton of lawyers. Texas also had kind of traditionally, and you tell me if this is still the case. I mean, although I know you're basically, you know, you're a criminal practitioner these days. But, you know, the sort of like swaggering cowboy kind of legal culture, very combative. You can practice, you could go your entire career if you're a Dallas County attorney or even a Collin County attorney, and maybe never see the same lawyer on a case twice, which of course lends itself to people being, you know, ridiculous to one another. I have found, you know, first in the 5 years I spent practicing in Wisconsin, and then the 7, I don't even know how long I've been here, to be honest with you. However many years I've been in Indiana, with the smaller bar, you know, the average person you're dealing with, if you can kill them with kindness, and it's remarkable how easy it is to kind of then get that person sort of under control. Not where you're manipulating them, but just where you've kind of sent them this message. They don't really know, like, what is going on with this dude? And then I just found it has the effect of checking them and kind of keeping their worst impulses at bay. You know, I don't know. I mean, it's
well.
Hey, you live and you learn, Jeremy. You live and you learn, buddy.
There's a lot to that. There's a lot to that because it's sort of kind of getting at what you're getting at, and this brings up another favorite topic of mine, which is Tarrant County. But Dallas and Tarrant are two very different places. Dallas, right? Yeah, you're exactly correct. You have so let's talk a little bit about litigation and what litigation is, because you are the chief of litigation for a department with the Indiana state government. But at the same time, litigation, basically, for those who don't know, that's courtroom work, right? That is going to court. That's suing people, defending people who are getting sued. In a form, doing criminal law. I'm doing litigation because we're litigating and we're in the courtroom, right? It's just criminal litigation, which acts a lot differently. But in Dallas County, there's so many different kinds of law firms, of businesses, of parties that are going in and out of the court system. And not only that, but you have dedicated civil courts in Dallas County, which I think in many ways kind of feeds the culture that you're explaining, which is we're never going to see the same lawyer twice. So if I stab you in the back and I just knife you, right, like this is a street fight, if that's how the lawyers are litigating, well, then there's really, I'll see you again in 12 years. And so there's no real accountability to that. And kind of what you were saying too with the call me Chip, that was one where because when I left the DA's office, I had the idea, and my journey, my path was that I did work for some plaintiff lawyers probably right out of law school, and I kind of got given the controls to airplanes I probably didn't need to be flying at the time, and so I got to deal with some pretty hardcore civil litigation really right out of the bat, and then when I left the DA's office, I spent time at the DA's office. I was going to kind of transition back to that, and what you would find is you would get these lawyers who were at big law firms, and they were very, very aggressive, and they were under a lot of pressure too. I think is part of it, and they would say, "Oh, you pick up the phone to them for the first time that you're talking to them in the case, and they say, 'Oh, Jeremy, oh yeah, I'm not one of those stuffy types. We're going to be friends here. Call me Chip. All my friends call me Chip,' something like that, right?" And then, "Oh, thanks, Chip." And then so I hang up the phone with Chip, and then Chip promptly sends me 18 motions in my fax machine back in the day, or via email. Chip will go on and blow up my phone. He'll send me 18 confirmation emails about to confirm our conversation we had of this and that. So very,
that's his game.
Yeah, that, and their job is to kind of bowl you over in some ways, but then when and to some degree kind of kill you with paper cuts in certain other ways that I don't want to get too far down that rabbit trail. But then after like 2 weeks of Chip just kind of just living on your shoulder and crapping on you for 2 weeks, it's like, hey, he calls you back. "I told you to call me Chip." You get a lot of that stuff. Talk a little bit, John, about your experiences in big law and that type of lawyer.
Well, I am happy to report that since leaving Texas, my encounters with that kind of a lawyer have been pretty few and far between. Somebody like a great lawyer once said, when you're dealing with an attorney on the other side who's just unnecessarily difficult, or is being difficult as a strategy, doing it on purpose, or is being difficult because they're crazy or just, a shit person, let them dictate the tone. Let them dictate the tone. You focus on dictating the direction of the litigation, which is, sort of another way of saying kind of turn the other cheek. Just keep your eye on the ball, which is getting the result, and don't retaliate. Don't let yourself get caught up in the petty games. And that's good advice. I think it's hard for lawyers to it's hard to be on the receiving end of that sort of thing. And even in state practice, when it has happened, it has been under circumstances where there are lawyers and there are law firms who, they'll look at the state's attorneys and they'll think, hey, these guys, they have, even though there's a ton of these, deputy attorney generals or whatever, I don't know what Texas calls them, if they call them like assistant attorney generals or what have you. But yeah, there's a bunch of them over there, but, they're not resourced like we are. They're not, they've got a million things going on. They got a huge docket of cases that they're handling. I have all of these young associates and junior partners that I can throw at this, at this case in addition to my own work. And so you'll see the situation where, and it's only happened, there was once very, very memorably, maybe only a couple times on some of the high stakes stuff. And I think later on we can get a little bit more specific into, the types of cases that someone in my position was handling or would, be handling, even like an analogous person or an equivalent person in the Texas Attorney General's office. When the one or two times I saw it, it was really a situation where, we're going to overwhelm the state with bullshit. And then while we are doing that, we are also going to play that game where we're going to constantly call you on the phone and email you, wanting to talk about the case. And then when we talk about the case, I'm always going to have a young associate sitting there with a laptop, like basically making a transcription of our conversation in real time. And then eventually I'm going to have to file a motion with the court, and I'm going to note the conversation we had, misrepresent the conversation that we had, right? And since I have this transcript of our conversation, that when I talk to you now 2 weeks from now, and we talk about the same thing, and I feel like your answer has changed, well, I'm going to make sure that I bring that point up, because I'm able to spend all these resources on keeping my thumb on you, and there isn't a lot you can do in response, which is true. In that case, it was true, because we had, you have a relatively small team of lawyers, and we are balancing a lot of stuff. But, the thing about the average state's attorney you're going to be dealing with, and I say this exclusive of prosecutors, because I think anybody that you yourself, Jeremy, or anybody that that does criminal defense, you have your own. You've been dealing with prosecutors long enough that you're really better to speak to, that sort of the mindset of the average county prosecutor. But, as far as any practitioner who happens, all 7 people who are listening to this, if you're dealing with state's attorneys, a thing to keep in mind, granted, we're not making big salaries. In some cases, state's attorney's office will hire lawyers right out of law school. Now, just as an aside, and this is a subject for another day, I don't know that the positions that we had were entry level, right? Because you come in and you're immediately given a ton of discretion, a ton of responsibility. And I don't know how much you remember from 2002, but I remember not knowing a whole heck of a lot as a second year attorney. The thing to remember about state's attorneys is, if you find yourself up against us, yeah, you may have a perception of the lawyers in that office, good or bad, right? But you got to remember, whatever it is you're litigating against us, it's what we do, okay? So on balance, we know the subject matter. We know the law probably better than you do if you are just a dabbler. Unless you are the ACLU, or a plaintiff's firm that, likes to sue or will sue the state on behalf of clients, over very specific issues. Most lawyers that we would deal with at the AG's office, they take a case, they do employment law. It just so happens they have an employment law case, and the employee who was terminated was an employee of a specific agency. Don't assume that we don't understand labor and employment, right? Because those are the cases we litigate for the state, and we litigate them very successfully. So you really are going to find yourself in a situation where you're litigating against an office of people who all we do is the type of stuff that you're trying to do on this one particular case.
Mm-hmm. You're watching JP, Kathy, and the Crew Network. You can watch and listen to JP, Kathy, and the Crew between 7:30 and 9, Monday, Wednesday, Friday. This is the Lawyer Show. We're on between noon and 1 on Thursdays. And my guest today, I'm your lawyer, Jeremy Rosenthal. My guest today, my co-counsel is John Nagy. He is Chief of Litigation for the Indiana Department of Health. That's a great point that you make, John. And some of the best lawyers that I have ever really come across in any regard are lawyers who, for instance, federal public defenders. The word public defender gets this. There's unfortunately a stigma that's kind of attached to it. But the federal public defenders, those guys do amazing work, and they are all to a person incredible litigators, if you will. They all know the subject matter inside and out. They know the sentencing guidelines inside and out. When you pick up the phone to call and ask them a question, they're not going to let you hang up until they're confident that you know the answer. The same thing with state public defenders as well. They tend to understand mental illness extremely well, and other really germane issues, not just mental illness, but they see it on such a frequent basis. They see it all day, every day. And so for a practitioner who does it not as often, it's an excellent point that you're making, that yes, you can take all the notes you want. You can throw all the associates at me that you want. You can lecture me all you want. You can send confirmation emails all you want. Ultimately, though, that's right. You guys know the cases in such a detailed way. You know the case law in such a detailed way. You know when cases are going up on appeal that are going to affect the things. You know when somebody is, for example, when you were with the AG's office, sovereign immunity might be an example of where your 2 or 3 or 4 cases that are go-to, and also because you're in federal court on those, what certain judges are going to do given those cases. That's really hard to beat. And so let's talk a little bit about when you are litigating on behalf of the government, when you are litigating, and let's take a step back too before we do that. So when you are describe to everybody what a lawyer for, because I know you're with the Department of Health now, but kind of before that, and this is really sort of akin to that, you were with the Attorney General's office in Indiana. Talk about what an assistant attorney general does, and then talk about basically what you do as the chief of litigation now for the Department of Health.
Well, as far as the AG end of that, as you probably know, the sort of bucket of legal issues that the Attorney General handles is wide and varied. The specific things that we handled, being a litigation attorney, because you've got consumer protection attorneys, you've got Medicaid fraud attorneys, you've got advisory attorneys. If you're in the litigation division of the average state attorney's general office, I think this is true, across jurisdictions. Every state is set up at least somewhat similarly. The bulk of what you're going to be doing is representing the state and its employees in litigation in state and federal courts. And that could be anything from inmate lawsuits, alleging, excessive force, or that they've had some sort of a deprivation of a constitutional right, employment law cases, administrative law cases, if they reach a point where the matter has been escalated to an Indiana state court. We would work with virtually every single state agency. The way that Indiana is set up is agency lawyers are not, by law, they're not allowed to appear in state court on, certain types of matters that are also by law exclusively within the jurisdiction of the Attorney General's office. So for example, now me being at the Department of Health, if we have, and we'll stick with employment law because that's everybody understands that. If we had a disgruntled employee who had been terminated and sued the Department of Health, alleging that their termination was discriminatory, that they're a member of a protected class, et cetera, I am barred by law, by statute, from representing those employees or those agencies in state court because I'm an agency lawyer. What I would do then is when that lawsuit comes in, we would make a referral to the Attorney General's office, and the Attorney General's office then controls the litigation.
Okay.
What we do as agency lawyers is we handle the administrative law matters all the way through the administrative law process. So we'll have, using the Department of Health as an example, if there's a licensing matter, maybe a license has the state wants to deny a license application in a certain area or do a license revocation. All of those steps play out administratively, and ultimately it would be heard by an administrative law judge, and if there's an appeal, an administrative law appeals panel. That's the big difference between what I do now as an agency lawyer versus what we did over the Attorney General's office. But basically, if you are a deputy in the Attorney General's office, you are a generalist. And on any given day, you could be doing, your Monday, you might be working on a civil rights case. Tuesday, you might be, you might be sitting in your office scratching your head for 8 hours trying to figure out, Medicaid eligibility rules. Wednesday, you're probably out at the prison. Right? Thursday, it's employment law, right? You got a Department of Transportation employee who's all up in arms and suing all of his former supervisors. So yeah, it's pretty varied. Like I said, I don't think a lot of the stuff we do is very entry level, but I have been, in the time I spent in the Attorney General's office, I was really, really impressed with the quality of, the young lawyers that came through the agency. I called it AG's office and agency too. To be able to, be under fire from day one, you're kind of running around, your hair is on fire, but we would be getting results. And there was a time, probably the first year I was over there, I was shocked, right? Because it seems so chaotic, because there's just so many cases that everybody was handling. But we end up, because and in part, the state has a toolbox of defenses, like for example, sovereign immunity, that are not available to your average, private sector civil litigant.
So let's
but
break
nevertheless,
this.
I mean, we would win far more often than we would lose.
So to break this down a little bit, okay, it's hard to sue the government. The government has, in most states, in most instances, there are laws which we call sovereign immunity. Sovereign being, I don't think that's Latin, but the king, right? That's what the sovereign is. And basically, sovereign immunity means you can't sue the king, right? You can't bring a lawsuit against the government absent really specific things. Let's talk about a few of the bigger cases that you worked on at the Attorney General's office, and I think that those are pretty good. For instance, you worked on a really interesting case that had to do with e-cigarettes. So talk about that for a little bit. Talk about how, for instance, that lawsuit arose, who brought it, and what all was involved in litigating that.
Oh, I get it. All right. Yeah. Another thing that you would find yourself doing, and I know that different states are a little bit more specialized, and Indiana has since become pretty specialized with which lawyers are handling what kinds of cases. But back in the day, and by the day I mean 2015, 2016, when we were just sort of a general section of general purpose litigators. When you would have, an act of the General Assembly, an act of the state legislature that is being challenged in court, and in the case you mentioned, Indiana was one of the first states to kind of try to get its arms around the e-cigarette problem, because it was at the time very unregulated. The FDA didn't even have, they hadn't come out with any sort of a deeming rule, which is in effect, the FDA's official position statement on e-cigarettes. None of that would happen, or none of that had happened. And so it was total Wild West. And everybody, like, you could go to a farmer's market and you have people there selling their homemade e-juice, right, that they put in their vapors or whatever, but I used to know all the terminology. I haven't spent 2 seconds thinking about this since that case ended. But
I could have told you about this earlier this week, but I wanted to see the look on your face.
Right. Yeah. So it was the Wild West. So Indiana, I think, sort of made a well-intentioned attempt to get its arms around the issue. And of course, the small producers who were going to be affected by the regulatory scheme filed suit against the state, asserting that it violated the Dormant Commerce Clause. And I hadn't heard the word Dormant Commerce Clause since like 1997, right? And all kinds of stuff. So, Deputy Nagy or Deputy whomever would be sitting in his or her office minding her own business, and suddenly a case assignment would appear. And depending on the luck of the draw, or depending on, if you did, we didn't specialize at that time, but if you did kind of have a subspecialty that the section chief knew about, she would sort of steer cases your way. And just kind of by the luck of the draw, I ended up getting tasked with being first chair counsel on the e-cigarette litigation. And I was assigned to assist me as second chair, a guy who had been out of law school about 9 months.
Well, you also, but this was a case that made newspapers, and it's in federal court too, which described for everybody the difference between practicing as a state's lawyer in state court and federal court. And you already kind of mentioned state court, and some of the limitations, I suppose, as it relates to the Department of Health. But talk a little bit about the difference between state and federal court for those of our viewers. By the way, you're watching JP, Kathy, and the Crew Network. You can see JP, Kathy, and the Crew between 7:30 and 9, Monday, Wednesday, Friday. This is the Lawyer Show. We're on Thursdays between noon and 1. I am your lawyer, Jeremy Rosenthal. Co-counsel today is the Chief of Litigation for the Department of Health in the state of Indiana, John Nagy. Go ahead, John.
All right. Well, this is all, litigation that would typically be filed in federal court. So if you're a state's attorney, whether you're in Texas or Indiana or Wisconsin, you're going to be spending a significant portion of your practice over at the federal courthouse, which, and we'll come back to this in a second, which over time I grew to prefer to state court. So if you're the type of person who had been avoiding federal practice like the plague, like myself, for the first 15 years of my career, it was sort of a rude kind of shock of suddenly finding myself, in front of the Article III judges, and in particular the magistrates, on a regular basis. But using the e-cigarette case as an example, it was a federal lawsuit. Of course, this is a $1 billion industry. At the e-cigarettes at the time in Indiana alone, I mean, it was insane how much money these small and medium-sized producers, these mom and pop operations, were making. And there was a significant amount of media attention. I remember there was one hearing where there was a reporter from, I believe it was the Indianapolis Business Journal, is there with her stupid iPad. And she's like taking pictures of me and my co-counsel. We're like sitting there.
Well, and as the attorneys
doing this over my shoulder, and I'm kind of like, how did you get that in here?
And as attorney for the state of Indiana, you work for an elected official, so you can't really go out and shoot everybody the double bird.
No. And as a matter of fact, one of the big things, going back to, I know you were really wanting to jaw a bit about the good old days of, when we're clowning attorneys, Dallas County attorneys, and all of the nonsense
And
that you
Tarrant
would
County
see if
too.
you're
And Tarrant County
But
too,
Tarrant County, yeah, the
because
nonsense you see if you are a downtown Dallas lawyer, right? The thing about being a state's attorney is, and it does require at least some discipline, because you are representing the state, and because you are, in addition to being counsel, you're also an ambassador, if you will, for the Attorney General's office. A thing you do not get to do is you don't get to be a smart ass. You have to play it very, very straight because you are the state. All of the dumb and ridiculous things that you see other lawyers doing in the courtroom or just in litigation practice, you cannot do that. You are held to a little bit different standard. I actually preferred that kind of thing, or I like that was the mindset, because I was already hitting a place in my career where, I was into my 40s and, was much better able to do the whole type an angry letter responding to the lawyer and then put it in your desk and then come back to it the next day after you've cooled off. I was much better able to do that sort of thing than I would have been back in 2005 when I was kind of young and crazy and super combative. But yeah, representing the state, you've got to play it straight. You can't be a wise guy. I think the most cheeky thing I ever did in a brief I filed, and there's room for, you have your own writing style. Everyone has their own style. Within the framework of your writing style, I think the most subversive thing I ever did was putting in a big block footnote with a picture telling the judge what Dungeons and Dragons was.
That's pretty cheeky.
Because that was germane to the case. I took a really, really funny picture off the internet, stuck it in a footnote, and then explained to the honorable Article 3 judge, hey, Dungeons and Dragons is a fantasy game, and I'm talking about orcs and elves and nonsense.
Oh, you don't have to explain that to JP, Kathy, and the Crew Nation. They know what Dungeons and Dragons are.
Oh yeah,
they know all these things. So yeah, this is very.
But that particular case had a First Amendment issue, and the First Amendment issue at play was analogous to a First Amendment issue in a different case that was all about Dungeons and Dragons.
Well, you've brought this full circle, with the Dungeons and Dragons. Sometimes it's very interesting because I think a big part of some of the passive aggressive things that lawyers do, what happens, I found in civil litigation, is that you are behind your desk and you may have a really small role in the case, particularly as a brand new baby lawyer, right? And you sit there and you just read a request for discovery, right? What we call an interrogatory or a request for production or a request for admission. And you probably, it has an inflated importance to you as a junior lawyer. And you tend to, you're behind your desk all day and you're looking at that and you're looking at other similar things, and you really kind of lose sort of the big picture and sort of the perspective. And then and not only that, but you're having less contact with the other side. You're not seeing them in person necessarily. You're not, and you're communicating to them oftentimes in written form, which is no different than texting somebody. You lose a lot of nuance. It's very easy to get angry at somebody you don't see. It's very easy to be frustrated and pissed off at another lawyer that you can't really get a nuanced answer from. And not only that, you can really get trapped in footnote 41, right? You can just read it, and you read it a bunch of different times, and you're so convinced that you're right, and you never hear the other side of it. And so that's kind of what I think contributes to some of the combativeness when doing criminal law. One of the benefits is that I see the same lawyers a lot. Almost before the pandemic, you would see them every day. It's crazy now. I'm going back to the courthouse and I'm seeing folks that I hadn't seen in forever, and probably in some cases over a year, but it just feels like yesterday. But even with opposing counsel, it just really takes the sting out of it. And we develop in criminal cases a track record, probably to speak with certain prosecutors, and I might remind a prosecutor or not remind them of a case that we had 10, 12 years ago and something that may have happened there. So we definitely, but we can be aggressive within the litigation, but not necessarily hostile or manipulative to one another. I think that's kind of the big difference, at least between criminal practice and civil litigation. And kind of to your point, just kind of, all the way back to the beginning thing that you said was that when you're just really nice to the other side, it just makes it hard for them to. It just takes a lot of steam. It takes a lot of steam out of them. Talk a little bit about, to kind of transition a little bit. So the Department of Health. Talk about the Indiana Department of Health and exactly how that works, how that is, and what's big picture scheme. How does that look as far as lawyers go and litigation?
Well, hey, before I get to that, there was, what you just said, man. You really nailed it.
That's why you're on the lawyer show, because compliments go a long way with me. That's why you were here, good. Because I knew that this would happen.
Look at that.
We're solving it. Yeah, go ahead, John.
Yeah, what you said, talking about, the repetitive nature of the practice, insofar as you're going to be seeing some of the same prosecutors over and over and over again. And as you have put it a number of times in the past, there's not that's kind of the genesis for my approach to practice now was back when I was doing insurance defense in Wisconsin, in-house with the insurance company. You would see repetitively the same plaintiffs' lawyers over and over. You would see them, they would see you. You kind of figured out pretty quick who the dicks were. The dicks were actually few in number. I made it a point to forge at a minimum cordial relationships with these lawyers, because it's like, look, I'm going to have to deal with this dude again, right? I mean, let's not fight about stupid stuff. We all know the score. Let's just litigate this. In your practice, having a lawyer that you hate on the other side, I guess there's two ways to look at this. On the one hand, having a lawyer on the other side that you hate makes, and in particular, if it's those lawyers that we talked about at the top of the show, the ones that are gaming you and blowing you up with discovery and just playing all the nonsense games, having a lawyer on the other side that you hate makes the whole litigation process painful, but it makes the trial easy. Because by the time you get to the courthouse, you are ready to stab them in the throat, right? There will never be a question in your mind that you are not prepared to give them the business. And that when you're standing in front of those jurors, right, you'll twist the knife.
But you got to be careful. You got to be, oh, sorry, John, I didn't mean to cut you off, but you got to be careful, because there are arguments that feel good and there are arguments that win, and they're not necessarily the same thing. You cannot allow them to draw you offside to the degree that it hurts your case. And there are times where I will, you catch yourself. We're people. We can be emotional. There are times when I'm in front of a jury, either I'm sitting at counsel table next to my client, listening to a witness talk, listening to a prosecutor give an argument, where my first reaction is to take things personally, or to react in a way that says, well, let me tell you how they've been cheating. Let me tell you how I feel like they've been. Let me tell you how they've been kind of idiots here. But the jury most of the time doesn't care about that. And the jury wants to do, in each case, they want to do what's right. They want to achieve justice, if that's something that you can use in that context achievable, that's what they're focused on. And so when you just get up there and go after the other side, that's only marginally effective. So you can't be pulled off sides about that. But yes, when you really don't like the other side, if you can channel that energy, it's just like Star Wars, just like Darth Sidious, right? Use your
it manifests itself, if you will. It manifests itself in the motivation that the other side is providing to you to fully litigate the case. Flip side to that is when you have a lawyer on the other side whom you like, who's very professional, who's a good lawyer, who's good at what they do, it makes the litigation process much smoother. Your day-to-day is much more enjoyable when you're working on that particular case because there's no BS, right? Everybody knows the score. Maybe even, have cultivated a little bit of a relationship with that lawyer where you get to know him a little bit. So it's great, right? It's from a lifestyle perspective, it's great. The whole process of handling the case is awesome. But then you get to the courthouse, right? And the only thing worse than a likable plaintiff is a likable plaintiff's lawyer. And similarly, there's nothing worse than a likable defense lawyer. And so that was what I would always be selling, right? Hey man, I'm just trying to make, ladies and gentlemen, I'm just trying to make sense of this crazy world we're all living in, right? I mean, I'm just like you. I'm trying to figure this out. But when you have a lawyer on the other side that you like, number one, you're thinking, well, geez, if I like this guy or this woman, a jury's probably going to like them, right? and I'm being paid, and my client is counting on me to be skeptical of that and to counter that. So if I like this person, the jury's probably going to like them. And, when it comes time, some lawyers make it easier for you to put on your show and shoot off your guns and make your arguments because they have pissed you off and they have motivated you. When they haven't done that, but you're still having to, give that spirited argument or, woodshed somebody on the witness stand, it's still like if you're playing basketball, it's pretty easy to hack a guy that you hate who's been trash talking you the whole time. But if it's your best friend and he's driving and it's 10-10 and you're playing to 11 by ones, right? I got to foul him. I got to stop this, but I don't want to hurt him. There have been moments where I have kind of caught myself okay, I need to, I can't pull my punches because this is the trial, this is the show, and I got a job to do.
You're watching JP, Kathy, and the Crew Network. You can see JP, Kathy, and the Crew between 7:30 and 9, Monday, Wednesday, Friday. This is The Lawyer Show. We are on between noon and 1. I am your lawyer today. My co-counsel is John Nagy. And to your point, John, I think that particularly as a criminal defense lawyer, I have to have an Alamo to defend. There's something in every case I have to get upset about. And fortunately, there almost always is. And when the other side is reasonable with you, and when the other side is very level, and they've done a really good job, and there's really not a lot of, even from my perspective, if I have a hard time finding injustice in what's going on against my client, it is a challenge to give that very spirited. It is a challenge to be to be a zealous advocate, although again, I find it very, very rare that's not the case, and particularly if I'm in trial. If I'm in trial, I start believing my case. I start believing in my case. I start believing in what I'm doing, so it tends to build momentum. Where it gets frustrating is at the very beginning of the case when the prosecutor picks up the phone and says, "Jeremy, we just don't see it here. We're going to be dismissing this whole thing." And I'm like, "What do you mean you're dismissing the whole thing? You guys have never done this before." And then I'm like, "Oh, wait, thank you. Bye." And in which case, a lot of times I have to cut a fee back to my client, which I don't, that's just, that's okay. A guy who, there's a saying, a really good lawyer friend of mine, his dad is an old-time country lawyer from Nacogdoches, Texas. And the saying is, a guy who sues your client can't be all bad, right? So anyway, kind of along that same vein, let's switch gears a little bit, John. Talk about the Texas A&M School of Law. That's something that I find really, really fascinating, and it's not, again, necessarily germane to any of the topics that we've had so far, but this is a factoid that you hit me with, I don't know, maybe a month ago that really kind of stunned me. So go ahead.
Let me tell you, man, I mean, that it was me who was able to break the news to you about the Fightin' Aggie School of Law and to get your real, spontaneous reaction to that news was sublime.
Okay, so why don't you?
So much fun.
So let me give the backstory.
Yeah, I imagine anybody who knows anything, well, maybe people don't pay attention to it. And, I guess when you think about it, do we really care about this information?
Not really, but that's okay.
I thought it was pretty significant that the Texas A&M Law School, formerly Texas Wesleyan, had in the 2021 U.S. News and World Report rankings passed every single law school in the rankings
except SMU.
SMU and the University of Texas.
So so let's give a little bit of background to everybody who may or may not who may not be a lawyer. So there are how many accredited law schools in the state of Texas? I think 8, 9. Are they up to 10 now?
I think it was more than that. I think there's like 11 or 12.
Okay,
there's a bunch.
So
there's a bunch you always forget about, but they're there.
Okay, so there's that many schools in Texas that are accredited as law schools, and by accredited that means whatever national association of accreditation, but also more importantly, if you don't go to an accredited law school, you cannot sit for the bar. So that's probably the main threshold to it. And U.S. News and World Report, they come out and they give these rankings, which, I mean, people like to blow them off and say, they don't matter, but they kind of matter. And a lot of these things are sort of based on some kind of hardcore empirical evidence, which is your bar passage rate, right? That matters. That's not a number you can fake. Also, I think they measure the size of like schools' endowments. What else do they put into that equation?
I think, historical reputation is a big part of it.
That's where they lose, folks, because it's so subjective. It's like, well, SMU is just great because it's great, and SMU's got a lot of old money because it's got a lot of old money.
It's helpful for the schools at the top. I mean,
for
Yale
sure.
is you're never gonna open the pages of U.S. News and World Report and see that Yale has fell from 1 to number 17.
But that's also because
unless they're making the students like take all their classes outside in the winter with no coats on.
Well, okay, but what they're also doing here too is some of these stats are probably self-perpetuating. In other words, Yale has a very big alumni base, I'm sure, in New York City, and those lawyers make a ton of money. And what do they do? Who do they hire out of law school? Well, they hire Yale grads, right? Why? Because you're a Yale grad, and so Yale gets to score more points with U.S. News and World Report. Because, well, all of our graduates are coming out and they're making all this money. And then so that type of it is sort of subjective and is sort of cyclical, but they also focus on who are your faculty. I don't know if it's how much your faculty is being paid. Part of it is how much money do you have in your endowment in your bank. But again, probably in Texas at least, the most objective criteria would be the bar passage rate, because again, you can't fake that. But so to kind of go back to Texas A&M School of Law, so they were not always Texas A&M School of Law. In fact, they became Texas A&M School of Law 7 or 8 years ago, maybe?
Something like that, like 6, 7 years ago.
Okay. They bought a school called Texas Wesleyan School of Law, and Texas Wesleyan's still a university. They just had a law school that was in Fort Worth, and it was in the rankings struggling, or relative to where they are now struggling, and so they were. So I don't know what their ranking would have been, but it. Do you remember where it was originally?
It was like in the high hundreds, man.
Okay, and so. And I hadn't read this in a while, but you told me a few weeks ago that you said SMU is number 52, which is about where we are most every year, right? Some years we're up 48, 49. I don't know how high we've gotten, but then we will bounce back down, and we kind of trade spots a lot with Baylor because Baylor has practice court, and we've talked a lot about practice court on the show. But also but then you told me 2 or 3 weeks ago that SMU was 52 and A&M School of Law was 53. I about ran a red light in my car when I heard that news, or hopped the curb, because that is a stunning increase and they're ahead of Baylor, which Baylor people ought to know.
They need to know.
Yes, they need
Baylor Bear needs to know. That's
right. They need to have this kind of shoved in their face. But then again, as I've told you, as SMU grads, if their trajectory keeps going the way it's going, we're going to be looking up at them, I'm sure, here very, very shortly. And you also said this about Texas A&M University, that it would they're not going to throw a stinker out on the field. They're gonna put some money, they're gonna put some resources into law school. I don't know what they've changed. I know plenty of people who've graduated from there that are wonderful lawyers that are from Texas Wesleyan, that are very competent, very skilled practitioners that I trust with some of my, with if I ever have a question, there's some that I know I can pick up the phone and that they'll answer. But just from that ranking standpoint, that was, man, that did kind of. Let's talk about. I do need to tell a story here, John. About.
Well, we're almost out of time, aren't we?
Well, do you want to talk about which case? Do you want to talk about the state? Well, I can't say my client's name. The criminal case you helped me with, that you helped me try as second chair, or do you want to talk about Potter v. Schrackle?
I want to. We need to go back to the beginning, dude. We need to go. We need to
Potter v. Schrackle
all the way back. Potter v. Schrackle.
Okay, you take it away.
I have actually, this is no joke. I have, on more than one occasion, kind of Googled around because it was, I think it was a NITA scenario that we were using.
Yes. Uh-huh.
And so I figured, well, this has to be online somewhere, right?
Mm-hmm.
And we know that Potter v. Schrackle is, at least 22 years old, 21, 22 years old.
Our client was Schrackle, right?
Yeah. And wasn't it a state of Potter?
A state
he got ran over by that. I don't think he survived the El Camino.
Did our client
strike.
die in that? Okay, so this is the law school.
No, we had the driver, dude. We had the driver of the El Camino.
Oh, yeah. Okay, no, we were the defense, right? So, okay. So this was a law school mock trial problem that we did for a class, and our client was driving an El Camino. That I remember that.
Yes.
Yes, our client was driving an El Camino, and who did we run down? Who did our guy ran over somebody?
He was making a left turn at a controlled intersection, and he ran over Potter, who may or may not have been in the crosswalk.
That's right. That was the question. And was Potter a kid? Was Potter a little kid?
No, I think Potter was just Potter.
I think there was a child witness, and the whole issue was what side of the line was the guy in the crosswalk or not in the crosswalk, right? And I think we learned, and so it was funny because they had us come to the Dallas County Courthouse, the civil courthouse, on a Saturday. They told us to bring a whole ton of quarters because we weren't going to get out of the parking lot if we didn't bring a bunch of quarters. We didn't really have a jury and so they asked our friends and family to be jurors. So we never really got to do a jury selection, and I got to learn extremely quickly just how important jury selection is. We got to watch the jury deliberate, right? Did we watch them deliberate? I think we did.
That sounds vaguely familiar.
And there was one lady who, and we put a lot of work into this, and we're wearing our suits, and we're just, we're getting into, we're doing our cross-examination, and we're trying all the awful ideas that the lawyers who never tried cases tried to teach us. And I remember the very first lady who started talking and said, if you're driving in El Camino, you're just guilty. And I mean, it's just like, man, everything we did was worthless on this lady. And so, but fortunately, I think the other 5 people we didn't zero out the plaintiff. We came close.
All I remember is we won.
Yeah, we won.
We did win.
And there was a big party that night.
Yeah. And unfortunately, I just, with my Google searching, I was not able to run down a copy of Potter v. Schrackle. I tried to find it, not for this podcast, but just, because I thought it would be funny.
For good times.
For us to revisit it.
Because it's funny when people get run down with an El Camino, which, and every time I see an El Camino to this day, I think
same as I as well.
I think Potter v. Schrackle. Now, I am going to kind of do a quick. I am going to tell everybody, the jury. So you were at one point in your career criminal law curious. You were eyeballing it. And you were thinking this might be for me. So I invited you up to Collin County, and we tried a criminal case together. And man, this was one of the first defense juries I had in 2005, and it was a possession of methamphetamine case. And this is the main thing that I remember about this trial.
That meth is fun.
What did you say, that meth is fun? I don't know that our guy would agree with that. Well, maybe he would. In fact, maybe that was the problem. But we were a good team. Just like Potter v. Schrackle, man, we were a good team. We had, I was kind of the busybody, active, kind of everywhere, and you were just sort of the stone face, right? And I don't think the jury quite knew what to make of it. And you really didn't say much during the trial. You kind of talked to the client a little bit. You were there just sort of taking notes, kind of doing this. And then when the prosecutor offered the methamphetamine into evidence, right, to satisfy the corpus delicti rule, which says that, the body of the crime, that the prosecution has to prove that this substance is what it is, so they're offering this into evidence. The prosecutor's walking over to me to hand me the meth in the bag. You jump up and you snatch it from the prosecutor. And then you look at it. You kind of did one of these, you kind of looked at it in the light. And then you kind of did a really good nod. You were like, yeah. You give it back to the prosecutor. And that was the only thing. And, of course, when the jury comes back, whenever they came back a day or two later with their verdict, that was the only thing that they wanted to know about. Was what was he looking for? How is he doing it? Man, I feel like that's kind of what you were going for.
Well, you know what? That's the first. This has been mentioned in probably 15 years, and I had totally forgotten about that until you said that just now.
Well, it's again.
You left out the part of the story where after I handed it to you, then I turned to the jury and kind of like mimicked lighting up a meth pipe.
I must have been focused somewhere
and then
else.
I put it down and I nodded. It's like, yeah.
That's what this stuff is.
Well, I note that was my first and my last criminal defense trial.
Man, so that guy got arrested. I don't know if you remember, that guy got arrested right in front of my office and in front of my law office, which is kind of trippy too, because it's like, how did they hire you? Well, back then I was, that was a court-appointed case I took right out of the DA's office.
That was back when you were just a scrappy upstart Collin County lawyer, and now look at you, Rosenthal, Calabas, and Therian.
That's
crazy.
Us.
Yeah, that's a big deal. That's a big firm.
Well, we are.
It's a big firm.
We are the biggest. I think the state bar doesn't like me saying that we're the biggest criminal defense firm in Collin County because they say you can't prove it, and I'm like, okay, find another one bigger. Well, shut up. That's their response. Shut up. You can't say that. So a lot of First Amendment issues when it comes to what lawyers can and can't do or can and can't say out there. One disappointing thing in Texas, I don't know if you know this or not, then we have to wrap it up, I'm told. One thing in Texas is the state bar, the lawyers have just voted and approved slogan names for law firms. So coming to a neighborhood near you, you're going to get, cheapdivorce.com is going to be, you're going to see those, so basically we're going to be like detergent and other type of products that are labeled by those types of names, which is, I think, disappointing. I don't know. I'm not one of these uber traditionalists about that type of stuff, but it's a little irksome just the same. So anyway, when you in a few years, when your wife, who is from the city of Richardson, decides to bring you back and your family and living here, when you are of counsel to criminaldefensefirm.com, a.k.a. the former Rosenthal Calabastarian, I look forward to that day. And in every trial that I have that involves methamphetamine, you will be the guy who inspects to make sure of whatever, right?
Not many can call themselves meth experts.
No, not many. Not many.
You.
This has been
Jeremy. You.
This has been a very successful episode of the Lawyer Show. Unfortunately, I think it's time to wrap this thing up and put 2 bullets behind the ear of this episode, behind the barn, put it out of its misery. But thank you, everybody, for watching, and I will see you again next week, if not sooner.